Hello and welcome to Law Talk. My name is Mitch Panter and I'm your host. Law Talk came about many years ago when my brother and I, Brett Panter and Mitch Panter, we were Panter and Panter back in the day. We decided we wanted to do something to help the community, so we developed a TV show called Law Talk. And we were in public broadcasting, WLRN, probably about 30 years ago. And the goal was to educate people, to help the community. So what we would do is we bring on different guests, most of them lawyers, some of them politicians or whatever was important in the community at that point in time. And we talk, we learn, we'd educate, we'd find out a little bit about what that person is all about and how they're going to help the community. Fast forward about 10, 12 years ago, and we formed what's called the Panter Panter Sampedro Network. The goal was to be able to have a lawyer to do everything. Panter Panter Sampedro is a law firm dedicated to protecting Florida's families. And one of the things that we like to do is never say, I don't do that. So one of the important aspects is to have a team, a stable of lawyers, of people that can help you, our community, do different things. So what we did was we sent out a blast to all the lawyers that we knew. There was more than 10,000 in Miami-Dade County alone. And as a result of that, we formed the Panter Panter Sampedro Network. We currently have about 150 members within Miami-Dade County and about 50 in Broward County. And again, the goal is when somebody calls us, because we do quite a bit of advertising, they say, I need somebody to do probate, I need somebody to do real estate, I need somebody to do criminal. Well, we don't do that work. Our focus is on personal injury, medical malpractice, products liability, premises liability. But we always want to be able to say, but wait, we have somebody that can help you. That's what it's all about. So we formed Panter Panter Sampedro Network. Fast forward to last year, we decided we wanted to be able to help people with a podcast, with this type of mode, and tell people a little bit about what areas of law they're interested in and what areas of law that we have connections with. Fast forward to today. We're privileged to have Justin Stivers here with us today. Justin became part of our network recently, and we're going to introduce him and let him tell us a little bit about himself and what he does. Justin, good morning. How are you today, sir?
Good morning. Good morning. I'm doing well. Thank you.
Who are you and what do you do?
Yeah, so my name is Justin Stivers. I am a probate and estate planning attorney. I help people prepare for the inevitable, which means I write wills, I write trusts while people are alive. And then after they pass away, I help them through the probate process to transfer assets, whatever they have, to their family members and to their beneficiaries.
Let's start with the basics. Where you come from, how'd you get up to the point where you're at now in your present practice?
Yeah, so quick bio, born in Florida, so native Floridian, raised in Knoxville, Tennessee, ultimately went to law school at the University of Miami before going, go you. Before I went to law school, I was in the Peace Corps, lived in Honduras for a couple of years. And so I'm fluent in Spanish, though I probably don't look like it.
Right.
And so I've been practicing, newer graduated in 2013. Started my law firm, Stivers Law, not too long after that, and we're based in Coral Gables right now.
So how do you get to stiverslaw.com? Not .com, but how do you get to Stiver Law without there being prior work or working for a firm, or did you work for somebody else, or just open up your own shingle?
I worked at a couple firms before starting my own shop. I had a title company with a partner for a little while. From that title company, I saw that there were a lot of people who had to go through the probate process, right? Someone owns a piece of real estate, they pass away, and now their kids are going to inherit that property. Before they can sell it, before they can do anything with it, it has to go through the probate process. And so I just saw kind of an opportunity. I felt like there was a real need in the community to help people to kind of transition through that process. And then that's, I kind of built my network, working with that previous partner, realtors, other attorneys being my primary source of business, and then started the firm in 2017.
Awesome. So how'd you get involved with Panter Panter Sampedro Network?
Yeah, so Brett and I connected a little while ago, invited me to the office. Obviously you all do a phenomenal job marketing, everywhere, advertising. And Brett kind of just told me about it. He said, listen, we've got this network, 150 plus attorneys, all kind of specialized doing, one area of law, which, I'm a big believer in. I kind of what you were saying in your intro, there's a lot of stuff I don't do. I'm very specific in the things that I do. But I do get calls for other areas of law. So I like the idea of having, hey, this is a vetted, group of professionals who are, specialized in their unique area of law, so that if someone calls me and say, hey, I need to do a divorce, rather than say, hey, no, I don't do that, I can tap into the network and reach out. Yeah.
That's the goal. It's what we do. So you mentioned something which is really cool, the Peace Corps. What's that all about, and how has that helped you in today's world and what you're doing.
Yeah. So, in undergrad, I did my undergrad at a small school in North Carolina called Appalachian State University in Boone, North Carolina. I had the opportunity to do a lot of traveling in that time. I did several semesters studying abroad, and I just knew I wanted to, give back, do something good. And so ended up in the Peace Corps, went to Honduras, was there for about 3 years. Wow. Amazing experience, amazing people, amazing country. Just had so many great experiences that you don't have here. I mean, when you think living in a mud hut, I lived in a mud hut. Sure. When you think hiking up the mountain just to get water, I did that. So a lot of really unique experiences that I think give me a perspective on life that maybe other people don't have. If for anything, being in Miami and now being able to speak Spanish, that's a huge plus.
But also the background, the knowledge, the Spanish is one thing and that's wonderful, but to understand what these people are going through, Miami is a city of migrants and a city of immigration and everything that we are here, really diverse culture. So now you have, and it wasn't 6 months, you talk about 3 years you spent there. So you got to handle and be familiar with those kind of people and that kind of structure. And I'm sure it's helped you tremendously in dealing with your day-to-day today.
Oh, absolutely. I mean, just the cultural experiences that I have. I mean, probably one of my, favorite memories is the day-to-day was just, you walk down to your neighbor's door, you lay in the hammock, depending on what fruit seasons it is, you're eating oranges, you're eating mangoes, and you're just hanging out with the people. Right. I mean, it's beautiful. And yeah, it has helped me because Miami, we're such an eclectic, group of migrants, people from all over the area. So, if I have someone coming in from Central America or, South America, where I've traveled extensively, so you can relate. You bring up these things and it's not just, hey, I'm just a lawyer on the other side of the table. It's like, I can talk about, especially Central, America. I've been to so many different places that it really resonates with my clients.
All right, let's go to today. Probate, estate planning, trusts. I know I took the trust and estates class and that was the last I heard of it. What's it all mean? Give us some definitions. What's probate? What's estate? What's a trust?
Yeah. So I think a lot of people are confused about the two, right? And I kind of group them as pre-death and post-death. Okay. Pre-death is what most people think about. You're doing a will, you're doing a trust, right? And those are probably the two most common, quote unquote, estate planning documents. Most people are going to have a will or have heard about a will. And that's the document that says, who gets what of my stuff after I pass away, right? Very simple. Most people say everything goes to my spouse and then everything goes to my kids. If you're thinking that, most people are going to do a will. A trust, same idea, who gets what of your stuff, but it's a little bit more complex. You can add, things in there so that, your son-in-law doesn't walk away with your inheritance that you left with your daughter. There's a lot more types of things that you can do. So that's the estate planning. That's the pre-death. The post-death is probate, right? And so if someone, didn't do any sort of planning, or if their planning is maybe not complete, they're going to have to go to probate. And the way to think about it is, when you're alive, you own your stuff, right? And if you want to sell your house, you just go, you sign the title, and give it to somebody or sell it to somebody. You obviously can't do that when you pass away. So probate is the process of transferring title of whatever you owned while you're alive to your next of kin. There's going to be a court involved. There's going to be a judge involved. And that's really the probate process.
So let's talk about a will. It seems to be your basic general thing, and some people have them, some people don't have them. What's the pros? What's the cons? When do you have a will? Why do you have a will?
Yeah, wills are very common. I think most people, that's what they're going to think about. They're going to, whenever I tell someone I do wills and trust, their response is, oh, I've been meaning to do that, right?
Exactly.
Everybody knows I need to do it, but it's just something you don't really get around to. The pros is it's better than nothing, right? The pros is that it's better than nothing, and that at the end of the day, your family will go to court and it's going to be written down what your last wishes are.
So what can I write down? What are some of the things? I mean, I know my car, my house, my boat, but what else is usually within a will that's important for people to have?
Yeah, most people are going to their house, right? Their financial assets, if they have money in a bank account, if they have a brokerage account, if they have investment accounts, anything like that, they're going to say who gets that stuff. You might also put in there, for younger parents, who do you want to be the guardian of your children if something, God forbid, happened to both parents? So you might put that in there as well.
That's really important for our viewers out there. If you have children and your wife pass away, who takes care of the kids? And is there a law that says how that happens? And maybe you can overcome that law or by specifying what it is you want?
You want to have something down. Now, the court is going to, if you don't have anything written down, they're probably going to see who's petitioning, who wants to be the guardian. A lot of times they're going to look at next of kin. So that's where we see a lot of fights between in-laws. One set of grandparents wants to be it, the other set does. So I always tell people, put something down, and the court's going to defer to whatever your wishes were on that.
Okay. I'm going to throw fancy words at you. Testate and intestate. The little bit I remember from law school.
Yeah.
What's the difference? What does that mean?
Simple. Testate just means that you have a will. Intestate means you don't have a will.
So if I die intestate without a will, what generally happens? How is my assets, my liabilities? How does that get distributed and taken care of?
Yeah, court's going to look to next of kin. So it's actually, for better or for worse, it's pretty black and white as far as what's going to happen. The court's going to say, there's a hierarchy. If you're survived by a spouse, he or she's going to get it, and then down to kids and parents and brothers, sisters. Where it becomes complicated is if you remarried, or if you've got kids from another marriage. A lot of times we see families where maybe they're not your biological kids, even though you've been raising them since they're 5 or 6 years old.
Right.
They're not going to get anything if you don't have it written down. So that's where we see a lot of, that's why we stress you need to have something in paper.
So I'm a little bit older, just celebrated a big birthday, and there are many people that are a little bit younger. What age, what circumstance in life, when do you first sit down and say, hey, I need a will?
Yeah, there's a couple stages. The first stage is, I generally say, with young parents, right? And for that specific reasons of you've got minor children, what happens, if something happens to both you and your spouse. You might not have money at that point. You might not even own a home at that time. But if you have minor children, you probably want to put something down just for that specific reason. As you get a little bit older, then you start accumulating wealth, maybe, mid 40s into your 50s, you start accumulating some assets. You might start planning about how do you protect those assets, right? If you get sued, if you get in trouble, there might be more to protect at that point. And then the third stage, as you get older, that's really the legacy piece of it. Okay, now maybe I'm not working. I'm not so concerned about getting sued or anything, but how do I make sure these assets get passed to generations and my legacy is preserved?
So another fancy word, codicil modifications. So I'm 40 years old. I've got one child. I've got a spouse. Fast forward 60 years old. I've got 2 kids, 3 wives, a bank, a this, a that. Can you change a will? Is a will something that's a living, breathing document that can be modified?
Absolutely. And so in my office, we review everyone's estate plan every 3 years, complimentary, just because things are going to change, right? Your life situations are going to change. Now, I generally recommend you look at it. I do see sometimes where people maybe did one 20 years ago, and now they're like, hey, I think it's time to update it. What you want to look at is maybe the person that you listed as your beneficiary, they've passed away. Or in your will, you're going to list somebody as your executor, or in Florida, we say personal representative. That's the person in charge of everything. Maybe they've passed away. So it might be time to update it. Just because you do it once, it's kind of like, you don't just do it one time and you're done forever. There's going to be life changes, divorces, people passing away. So you're not updating every single year, and maybe not even every 3 years, but it is something you want to look at. They are living, breathing documents, so you can change them. You don't have to necessarily update them, except, especially being here in Florida, a lot of times we have clients who will move from New York or California or whatnot. Remember, those wills are state specific. So something that might be valid in New York might not be valid in Florida. And so at that point, you probably would want to update them.
Well, let's do that, go a little more deeper on that, because that's kind of important. A lot, as you know, most of our residents here are not Floridians like you, a native Floridian, but transplants, New York, Michigan, wherever they might come from. A will, if I'm understanding correctly, is not a Florida, which is not a universal thing, but a state specific thing. So how does that work, and what should we be careful about and pay attention to if we're coming from another state and maybe we have a will from a different state?
Yeah, it's a great question, because I have seen, I'm thinking Texas specifically, they have some laws that are very different from ours as far as what you can and cannot do. And so we had a client move from Texas here. They didn't update it. They passed away. And what the will said was not allowed. We couldn't do it in Florida, right? So the will is state specific. They're not universal. So if you're moving, I generally say, if you're going to become a resident, wherever you're a resident, that's where you need to have your primary estate plan. And one thing, just to, for people to know, if you have assets in multiple states, and one thing we haven't, we can touch on, is a will is not going to avoid probate. And so a lot of times what I'll see is they have a house in New York, but they have a house here in Boca. If all they have is a will, they're going to be doing probates in 2 states.
Okay. So let's finish up on wills, and then we can go into the probate and estate. a will, we know it takes care of money and it takes care of kids. What are some of the other issues? I would imagine how you get buried, cremated, where your remains go, if there's specific items you want to go. What are some of the other issues that we can include within a will to take care of our legacy, to take care of our lives once we're no longer there?
Yeah, I think one of the intangible things, and this might be an extra document, or what I would call an ancillary document, is we want to make sure that the legacy is passed down, right? Most people think of a will is money, is the house, is take care of the children, those things that you said. And yeah, you can put all of those things in there. Do you want to be buried? Do you want to be cremated? I have some people, or a fair amount of people, who want to make sure their pets are taken care of. So we'll put stuff in there for their pets as well. But the other piece of it is the legacy. So what we try to, have our clients do, have someone videotape you, share your legacy, because, your kids are going to remember you, maybe your grandkids, but your great grandkids certainly aren't going to remember you. And so we try to do things. We have, custom booklets that we give to our clients, fill out, because those things are going to be important, and you want your values, your lifetime experience to be passed down for generations to come.
So you touched on something really cool. Do you do wills, I don't want to say virtually, but is it a piece of paper, or can it be a recording? What's the pros and cons of that? I mean, today's day and age, everybody's recording. YouTube, you can find anything. Is it better? Is it worse? Is it legal? Is it not legal? How are wills? What's the document?
Yeah, unfortunately, wills still have to be signed, ink, paper documents. It's, I think that might change at some point. The rules have changed a little bit with COVID, what you can and can't do. But they can't be recorded. The recorded piece is more so the legacy, non-legal related stuff, more that personal things that we want to pass down.
All right. Probate estates. So you mentioned the big words, estate planning. At some point in life, you become important and considerate of your family, your legacy, your financial worth. What does estate planning mean? And then what do you do with it?
Yeah, estate planning is going to include the will that we just talked about. So I think about estate planning in two pieces. First, it's what most people think about, the assets, who gets what of your stuff, right? And so that's after death a lot of times. The second piece of it is more so while you're alive, and maybe what we might call incapacity planning, right? Because you're alive right now. And so we want to make sure that you're, as you begin to age, if you start developing Alzheimer's, dementia, or just, unable to function on your own, that the court doesn't step in. And we see that happen a lot of times in what's called a guardian or a conservatorship. Famously, we've seen the Britney Spears thing where there's the conservator. Right. And so if you're incapacitated, if you're unable to make medical decisions on your behalf or access your own finances, you will be brought into court. The judge is going to pronounce you incapacitated, and you're going to have somebody, and it might not be the person you want, in charge of managing all of your affairs.
How do you avoid that?
Put it into a will, put it into a trust, right? So that's another important piece of it, because you want to name who that person is going to be. Otherwise, the court's going to do it. So as part of the estate planning, we're going to look at those issues, right? Who can make medical decisions on your behalf? A living will, which is different from a last will and testament, is kind of end of life wishes. I call it the pull the plug document. It's basically, I don't want to be kept on life support, if I'm in a vegetative state. And then a power of attorney, right, is another important document to have, which is allow someone to sign documents on your behalf, access records on your behalf. So estate planning really, there's a lot to it. It kind of includes making sure your assets are passed down. It might include taxes, making sure that your family pays minimal taxes when you pass away. And then it's going to include the medical component of it.
All right, so let's break that down.
Sure.
You got a lot of different documents and a lot of different, and I know because I filled out the forms, I've done all these things. Let's first start with the medical. So right now I'm healthy, I'm able to make decisions, I'm hopefully of sound mind and body, and I can decide what I want to do medically. But, if God forbid, I have a car accident or I develop Alzheimer's or some other horrible disease and I'm no longer able to make those decisions for me, what document or how do I go about protecting just the medical part of it?
Right. So there's three documents, right? So we've mentioned the first one is the living will, and that's the pull the plug document. Don't keep me on life support. And the reason I like people to have that, if that's what your choice is, right? That might not be your choice, but if that's your choice, is you don't want, I don't think, to put someone else in that position to have to make that decision for you, right? It's a lot to have to ask a spouse to say, hey, no, I'm going to make that decision for him.
Presumably you talk to that person in advance and tell them, hey, this is what I'm doing.
Presumably, yes.
Okay.
Presumably, yes. So the living will, you're making that decision now. Hey, I don't want to be kept alive on life support. So that's the living will. The second is the healthcare surrogate. And this is giving somebody the authority to make medical decisions on your behalf. Now, this is not, you're probably not life-threatening vegetative state. Could be life-threatening, but it's more so incapacitated. Maybe you were in an accident, and so the doctor needs to speak with somebody. And unfortunately, just because you're married, they're most likely not going to speak with your spouse unless you have this document signed.
Really?
I've seen it happen. Oh. Yeah. So
who would they speak to?
That's up in the air,
Okay.
right? And so sometimes they might not be able to speak to anybody, right? And I've heard horror stories on both sides. Now, the doctor, most likely they're going to say, hey, you're married, we'll speak with you. But I have heard horror stories where they won't. So you want to have a healthcare document, and that's just going to give the doctor permission to communicate with you, and then you permission to say what kind of treatment you want.
So I know we'd come to you and we'd go to your law firm, and we go to you personally, and you prepare this document. What do I do with the document? Do I have a copy of it in my phone? Do I give it to my primary physician? And where do you have it so that in case that situation occurs, they know?
Great question. Yeah. So I always give the originals back to the client, right? So the client, I'm going to prepare them. We keep electronic copies, and then I'm going to give the client a USB with the electronic copies on there. But we actually just partnered with another company called DocuBank. And what they do is we will upload the living will and the healthcare surrogate to them. They're going to send the client kind of a little, ID card that's got a fax number on there, because most people aren't going to carry these documents, with them. And unfortunately, when they need them, they might be in a safe or they might be at the house somewhere. So this card they keep in their wallet. If it's ever necessary, they give it to the doctor, and the doctor will be able to call the fax number, and they'll fax the documents right to you.
So I personally have a primary physician that I've had for many years, and those kind of documents I send to him. We're in Miami-Dade County. There's Jackson and there's Baptist. Those are the hospitals for all practical purposes. Can you send it in advance to them? Do you got to wait until the circumstance arises? What's the best way to notify them before it's too late?
Yeah, so you did the right thing. You gave them to your primary physician. I recommend that to everybody. But like you said, you might be in a different county, and now you need those documents. If you've signed a HIPAA release form, that's another medical document that will allow your primary physician, assuming he or she has the HIPAA release form, to pass those medical records to the other doctor. If you don't have that, they might not, and they might not give those medical records, which is why we've been using this DocuBank, because it doesn't matter where you are. They keep your records stored electronically. And so wherever you are, if you need them, the doctor can just call that number and they'll fax the documents directly to you.
As technology develops, we'll have new and easier ways to do things.
Yeah.
All right. Conservatorship, guardianship. Everybody knows the conservatorship now with the Britney Spears. I know guardianships because we often have cases involving minor children under the age of 18, 21, whatever it might be, where they recover a significant amount of money and the courts appoint a guardian ad litem. Sometimes it's the parents, sometimes it's somebody else. So I settle the case. I get a kid $12,000, $15,000, $2 million. The child is 12 years old. How do I protect him, protect that money? What's the court involvement? What's your involvement in a circumstance like that?
So it's a big part of my practice, right? So a big part of my practice is working with trial attorneys, plaintiffs' attorneys, settling these cases and making sure that the proceeds that are going to a minor child are protected. Guardianship versus conservatorship, same thing, just different name. Different states use different names. In Florida, we happen to use guardianship. Okay. So for a minor child, depending on the settlement amount, usually less than $15,000. But if it's more than $15,000, you can't give it to the parents. You can't give the money outright. They want to make sure that the money is placed somewhere. So, and that's really where it might depend what the parents want to do, what the courts want to do, what the attorneys want to do. We might put some of that money into a guardianship account, which means that the parents, if they need money for the child, assuming the kid's young, they might need money for education, for health, for maintenance, to help with rent and all of that. The parents can access some of that money, and there's a lot of court oversight. And so there's some good things to that, because it allows for the parents to have access and to care for the kid. But there's fees, and there's, a lot can get eaten up, and I've seen some bad things happen in that. So there's usually a hybrid. And what I see a lot of trial attorneys want to do is they want to put some money into a guardianship account for the parents because they need money for the child. And then we might set up a structured settlement for the child. So the child is going to get it at certain ages. We might put it into a trust.
The prepaid college tuition thing is a big thing.
Correct. Yeah. If the child has, if the child's going to qualify for Medicaid or Medicare or something like that, we might have to do a special needs trust. So it's a very complicated, personally very interesting area, a very interesting area of law. But the goal is, when there's a settlement like that, we want to make sure the majority of the money goes to the intended person, which in this case would be the child.
And that's huge. So we frequently have these kind of cases, and we work with attorneys like yourselves, and we set up structured settlements and annuities so that the parents can't misappropriate the funds. So, we have cases where when the kid turns 18, 21, 25, 30, they get X amount of dollars. And the longer you stretch it out, the more that money's going to be. So it's really good for the kids. All right. Trusts. What's a trust all about?
I love trust, right?
Okay.
So I'm a big proponent of trust, and there's a lot of, I think, a misconception out there about trust that, hey, if you don't have, insert the amount, 10 million, 5 million, whatever it is, you don't need a trust. You can just do a will. Again, we've talked about wills. They're not avoiding probate. And that's probably one of the biggest misconceptions I see out there and that people don't realize. And the problem with probate is it's public. So everybody's going to know what you had. It leaves a lot of room for fighting because now you've got, siblings seeing what's going on. A trust is private, right? So when you do a trust and you put the assets into the trust, retitling everything, you avoid probate, which is great. So there's a lot of things that you can do. One of the things, people don't think about, again, I mentioned the son-in-law. You might not, as you're a parent, you want to leave everything to your kids equally. That's great. And maybe the kids are 40, and so you don't need it to be set aside for them, which is fine. You're okay with them getting the money outright. But what happens if your daughter gets divorced, right? And now that money becomes part of the marriage. And so he's walking away, presumably, with 50% of the inheritance that you had left to your daughter. So if you set up a trust, you can actually set up sub-trust, so that when the money gets left to your daughter or to your son, it stays in that trust. He or she still has access to it. They can still, withdraw money, but the bulk of it is going to stay in the trust so that if they ever got divorced, that money is set aside. So that's one of the great things. The other thing is, what if your son or daughter has, alcohol, drug addictions, or maybe has a bunch of judgments or creditors? We don't want to give that money to them because obviously with addiction, that could be really bad for them. Or if they've got bad credit, right, that's going to get scooped up. So we can, again, set up a kind of an asset protection trust, credit shelter trust for that child so that they don't have immediate access to it. So there's a lot of cool things. One of the things, we've been doing for our clients as of late is, listen, what if you die, your spouse remarries, and then they get divorced? Guess who's walking away with 50%? So a trust allows you to do a lot more things than just having a will. And it's not even so much about the amount. Even if it's $100,000, the cost sometimes between the will and the trust is negligible in the long term.
All right, let me go to the hard question. How do you get paid?
Yeah.
So, I got a little bit of money. I don't have a huge amount of money. I want to do everything you're telling me. I want to protect my kids. I want to protect my assets. I want to protect against the bad son-in-law. How do I pay you? What do you get paid? How does that work?
Yeah. So on the probate side, we're going to usually do a flat fee, right? So most of the time, so if we're working with a trial attorney, a plaintiff's law firm, we work the same way that they work. We get paid at the end. If they don't get paid, we don't get paid, right? Okay. On the probate side of things. On the estate planning, when we're doing the wills and the trust, we're generally going to do half, 50% upfront to get started, and then the balance within 30 days. And it's a flat fee. I hate that. So
whether you got 10 million or 2 million, it's going
to be the same price, okay, right? Now, once you get to 10 million or above, there might be some tax issues that might come up. But we do flat fee. I loathe the hourly rate. So as much as I can, I don't charge by the hour.
Okay. So we're coming close to the end. How do I get in touch with you? And do we work for you directly? Do you go through other lawyers, internet, social media? What's the best way to get a hold of you?
I try to be everywhere as much as I can. Best way introduction to learn about me, learn about my firm is just go to www.probatefirm.com. That's okay, the best entry point.
PROBATEFIRM.com.
That's right. Yep. That's the best way on all social media channels, including TikTok. We just started.
Okay.
Stivers Law is the handle.
STIVERS.
That's right. And then my email is just justin@probatefirm.com.
Excellent. And so I call you, I have a question. Do I get you on the phone? Can I talk to you?
I'm accessible.
Okay.
I'm accessible. Absolutely. Yeah.
It's one of the important things because we stress that, because when people call, if you call in the big law firms of the world, you're never going to speak to Mr. So-and-so and Mr. So-and-so because they're figureheads on TV. But when you call Panter Panter Sampedro, one of our advertisements is you speak to Mitch or Brett or David or Al or Josh, and that gives you an opportunity to learn a little bit better. I think it's important. I'm not that big that I can't talk to people. We are active in the community. We like to do things. I'm sure you too.
Absolutely.
You go to different events and activities and you educate people on what probate is, what estates are, give them the opportunity to learn, because that's, the more they learn, the more they know, the better it is. So one final word about trust and estates, go.
Do something. Right. I think, and whether it's with me or with somebody else, I've seen too many probates rip families apart, right? And it's usually the smaller stuff. It's usually, hey, who gets the photo album, who gets the family heirloom. Just put something down in writing. There's so many options. There's so many things that you can do. But whatever you do something. But
you got to do it right, because you see there's all kinds of social media and Googling this, and if you don't get the correct number of witnesses or the correct notarizations, it's null and void.
Well, I always use the comparison of, I could probably change my own oil, but I don't really want to, and I might mess something up in doing it. Same with law, right? They're documents, and you could probably find something fill in the blank, but you don't know really what you're signing. I've spent years and years of training, doing this, learning this, hundreds and hundreds of times drafting these. So use a professional. It's like anything.
Right. Yeah. One last time, how to get in hold of you?
Yeah, just go to www.probatefirm.com.
All right. Thank you very much, Justin. It's been a pleasure to meet you. We hope that our community has learned something today, and we thank you for your time. Have a great day.
Thank you.